My name is Jack Simpson-Caird. I'm the library clerk specialising in courts, judicial review, human rights and judges. And the title of my talk is The Role of the Courts in the Contemporary Constitution. Bit by way of background, before I joined the library in September, I was a public lawyer at the University of Sussex. So if this is a bit like a university seminar, then there's a good reason. That's my background. The aim of what I'm going to say today is essentially to provide an overview of the role of the courts in the Constitution with a particular focus on devolution and the Human Rights Act. We're going to do that by looking at three key cases which have arisen under both those constitutional developments. Each case highlights, I think, the dynamic and changing nature of the court's constitutional role at present. Then we're going to try and sort of tackle some of the central constitutional questions arising in those cases, the sort of difficult questions on where the proper boundaries are of the court's role in the UK today. And finally, we'll also try and explore some of the main arguments in the debate over the nature of the court's role in the Constitution. There's currently a lot of controversy in both academia and to an extent in politics on whether or not the courts have overstepped the proper boundaries of their constitutional role, and that's something I'm going to hope to draw out in some of the discussion. A few other things I thought might worth flagging up about what I'm going to say today in terms of its contemporary relevance to political debate, which is hopefully why you're here. Obviously, we've got reform of the Human Rights Act, which is on the way, we've been told. We've got controversy over the role of judicial review and constant changes to the role of judicial review that have gone on certainly over the last Parliament. Obviously, the context, the relationship between devolution and Human Rights Act is of increasing importance, and that's informed how I've chosen the case studies that we're going to look at today in terms of how are convention rights protected in devolution statutes. And so we're going to try and talk about that. And then obviously the inescapable thing of the looming legal action in the context of a potential legal challenge after the referendum. I think some of the cases that we're going to look at might give an indication of the way that, say, the Supreme Court might approach a challenge of a very political nature on some of those big legal questions. So hopefully we'll tackle some of those questions in this talk. And the main structure, I'm hoping to talk for about 20 minutes or so. I'm going to set out a bit of the kind of underlying context of the court's current role, and then we're going to go through the three case studies. I'm currently writing a briefing on the role of the Supreme Court in devolution, which will have a lot of the detail behind some of these cases. So if you feel that you want to know more, then I'll send you the briefing. My details are on the first slide, or you should be able to get them fairly straightforwardly. I'd also like to say, please stop me at any point if you feel like I'm losing you or I haven't explained some kind of basic point. Please do ask a question. I think we're small enough numbers that this could be fairly interactive. I might even ask you to ask you a few questions as well. Okay. Right. So the starting point, I think every good constitutional lawyer, the starting point for understanding what is the role of the court in the contemporary constitution is to look at the main constitutional principles. And obviously I think it's important to think about these because how you see these principles will inform your view of whether or not the current role of the courts is right or not. So first and foremost, parliamentary sovereignty is the most important, I would argue, in terms of understanding the limitations of the court's current role. So parliamentary sovereignty, Parliament has the right to make or unmake any law, means that the courts cannot, as they can in, for example, Germany or the US, invalidate primary legislation made by the UK Parliament for being unconstitutional. So that's a clear constitutional limit which exists on the role of the courts in the contemporary constitution. The second constitutional principle, and depending on your view, might be in tension with the first, is the rule of law, the idea that the core function of the courts is to ensure that government action is legal and falls within the parameters set by Parliament. And how you define the rule of law is highly contentious. You might define it to include things like protection of human rights, or you might define it more narrowly to mean something like legal certainty and the like. And then I think a third principle, which is sometimes overlooked, although not so much in these parts, is parliamentary privilege. And that's the rule that proceedings in Parliament cannot be questioned in any court. So this presents a real barrier for courts or political involvement, even in judicial review and devolution of the Human Rights Act. The courts cannot question parliamentary proceedings, and that is a very significant constraint on the way in which the courts operate. And your view on that will depend on what you think the courts should and should not do. And then I've got this statement from Lord Bingham and Jackson, which I think is a very succinct explanation of the court's role. Statutes create law. The proper interpretation of a statute is a matter for the courts, not Parliament. This principle is as fundamental in this country's constitution as the principle that Parliament has exclusive cognizance over its own affairs. So there you go, you have the courts and Parliament's role in juxtaposition, and in a way defined by these kind of core principles. So I think having a think about the order in which these principles should be placed is very important for you to develop your own view about where the courts are going and whether or not their current role and changes that are being proposed via reform of the Human Rights Act or reform to other constitutional reforms are right, will depend on where you think the proper order, what the proper order should be of these three principles. Okay, we all with me? Great. Okay, so let's look at the first case study. So this is a really fascinating case, which I think is often overlooked, probably because it relates to Northern Ireland, and I think people are, especially in London, not as much aware as they should be of Northern Irish politics. So this was one of the first major cases to reach the highest possible level in the UK on devolution. And the case arose because devolved government in Northern Ireland was suspended and then restored on the 23rd of September 2001. And then the Assembly elected David Trimble and Mark Durkan on the 6th of November. All fine so far. But Peter Robinson, then an MP and an MLA, sought to challenge in the courts that election because of a provision in the Northern Ireland Act 1998, section 16, subsection 8, which said, essentially imposed a 6-week limit, a timeline, a time limit within which the Assembly must elect its First Minister and Deputy First Minister, and that time limit had not been followed. So his argument was that following the principle of the rule of law and obviously parliamentary sovereignty, the Northern Ireland Assembly had no legal power to appoint the First Minister and the Deputy First Minister. So the court was divided, the House of Lords was divided on this point, but by a majority of 3-2, they rejected Mr. Robinson's argument. And I think what's most interesting, again, thinking of the kind of political context we find ourselves in now, is the reasoning that the majority and the minority employed. So the majority, Lord Bingham, said that essentially the Northern Ireland Act was tantamount to a constitution, and we don't interpret a constitution in the same way we would interpret the Road Traffic Act. And the reason that we don't is because, for example, the Northern Ireland Act was enacted in order to give effect to the Belfast Agreement and all the background, and it should be read in the context of that background, meaning, essentially, I won't read out the quote, that the Northern Ireland 1998 was designed to give rise to a workable political arrangement, and a workable political arrangement doesn't fall down if timelines are missed by one day here or there. So essentially, that's putting it a bit more crudely than Lord Bingham would have done, but it had to be workable. And if we think that 6 limit is an absolute limit, and if that limit is missed, then there has to be new elections and all the political upheaval that entailed, then that's simply not legitimate. And Lord Hoffman concurred, and the emphasis is on flexibility. But the idea that a constitutional settlement would never impose shouldn't be read rigidly. And the reason the majority judgment has been very controversial, the idea that sort of constitutional statutes should be read in a way which is different from ordinary statutes. And it's often pointed out that Lord Bingham, and to a lesser extent Lord Hoffman, are kind of public lawyers, people who come from a practice of interest in constitutional issues, whereas the other judges perhaps come from different backgrounds, and they rejected that argument, the dissent, and Lord Hutton put it, I think summarised the dissenting perspective very clearly in this statement, where he essentially said this is an ordinary statute and we should apply the ordinary rules of statutory interpretation, which is if a statute says you have 6 weeks, you have 6 weeks, and that is the way you should interpret it. And so one of the sort of, something I want to draw your attention to in terms of commentary is the Judicial Power Project, which is a project run by Policy Exchange, and it's sort of seeking to draw out debate on the role of the courts in the contemporary constitution, and they've got this list of 50 problematic cases, and all 3 cases I've chosen today are apparently a problematic case, according to them. And so they said that the majority adopted an implausible approach to statutory interpretation. So essentially, saying that they favoured the minority approach that we saw with the quote from Lord Hutton. I'm going to ask the audience, why do you think, what factors do you think may have influenced the majority in taking a purposive approach? Why do you think they were reluctant to rule that the election was illegal?
Was the straightforward policy concerns that it was first, you said that power had just been devolved and it was the first major issue that the Supreme Court considered on devolution. I suppose it is thought that the broader public policy interest in stable government in Northern Ireland outweighed strict doctrine on interpretation.
Yeah, exactly. So I think that's always important, because when you're reading the text and the reasoning, sometimes it's easy to lose sight of the political context, and that's absolutely right. And if a purposive, as it's known, a purposive approach would essentially avoid political conflict, then there's an obvious incentive there for a more purposive approach. I think that's right. But nonetheless controversial, particularly obviously because when we're talking with the House of Lords or the Supreme Court, you're setting a precedent which could have an influence, and you don't know if the next time that purposive approach might be used in a context, in a different context. Okay, any questions so far? Okay.
So you mentioned that it was a majority 3-2.
Yeah.
Was the third judge in the majority a public lawyer?
Oh God, that's a good question. I don't off the top of my head I don't know. I mean, Lord Bingham is always cited as the example.
Yeah. What about the dissenters? Were they like commercial lawyers, or were they more kind of contractual?
Well, I think it's just a point that people have in analysis of Supreme Court decisions when they split 3-2.
Yeah.
I don't think it's a fail-safe rule. There's a famous example in a case called YL on whether or not a private care home can be considered a public body, which was a very famous example of a 3-2 split along those lines. But I mean, I made the point because it seemed obvious in terms of the Bingham quotation, he's famous for writing books on the rule of law, that he was someone who favoured that sort of approach, whereas there are other members of the House of Lords then and now the Supreme Court who have, in their public lectures, have advocated a more restrictive approach to interpretation and come from a different legal background. So I think I'll leave it to you to do the added research. Okay, so second case study. This is a well-known human rights case, one of the most famous cases under the Human Rights Act, the facts of which are almost sort of, you look, I mean, there haven't been that many other cases like this, because this is such a leading case, I think, has been so influential, and the facts haven't, again, reached all the way to the Supreme Court or the House of Lords. Okay, so Guyden v. Godin Mendoza Guyden was a landlord who brought possession proceedings against Godin Mendoza, who was occupying a property that he owned. And the argument essentially was that the landlord said that Godin Mendoza could not inherit the tenancy from his deceased homosexual partner because the relevant statute, the Rent Act 1977, defined the person that could inherit a tenancy in the following way. If you look at paragraph subsection 2, for the purposes of this paragraph, a person who was living with the original tenant as his or her wife or husband shall be treated as the spouse of the original tenant. So the argument was that those words meant that because they were not husband or wife, or not living as husband or wife, that's the thing, they don't actually have to be husband or wife, it's as husband or wife. The gender of the pronouns meant that it couldn't be from a man to a man. And Mr. Mendoza argued that as a result of the Human Rights Act, Section 3, the court should read those words differently. That reading, that statute, was in violation of his right to a family life, read with his right not to be discriminated against, right to be free from discrimination on the grounds of sexual orientation. And Section 3 here of the HRA says that the courts must, so far as is possible to do so, read legislation in a way which is compatible with convention rights. So he asked them essentially to rewrite the words in subsection 2. It's not subsection, it's paragraph because it's a schedule. And that was an unusual thing, something that wasn't a power that wasn't available to the courts prior to the Human Rights Act. And again, I can't remember if it's 3-2, but I think it was there was assembly. I think it's 3-1 actually. The majority agreed with Mr. Mendoza that such a reading was possible. And again, I'll essentially summarise. And he said that the words in Section 3 of the Human Rights Act, which say "as far as possible," mean that sort of mere language is capable of being changed. That's not the most important thing for Section 3. It goes much further. It does give the court to actually go beyond what the words mean. And if you're following what I'm trying to say, then you'll see that that's quite immediately controversial. The limit that Lord Nichols, the point at which it has to stop in terms of interpretation, was if it was a meaning that was inconsistent with a fundamental feature of the legislation. So the Rent Act is not about the nature of male or female or anything to do with people's sexuality. It's about tendencies. So they felt comfortable that they could change the meaning to be compliant with convention rights without changing the actual meaning of what Parliament was trying to do with the Rent Act, which is to provide a workable scheme for renting. So they felt that they could find a convention-compliant reading of the Rent Act which didn't affect the fundamental feature of the legislation, and that is essentially the main limitation. And that has been that's the sort of the key statement in terms of the leading case on how far the courts can go under Section 3. But Lord Millett, following a sort of similar line to Lord Hutton, was very grumpy about this. I recommend reading his judgment. It's highly entertaining. It contains all sorts of bits about whether or not cats means the same thing as dogs, or if Parliament says there's a ban on cats, there can that be a ban on cats and dogs? And he goes into Siamese cats, different species. It's really quite an entertaining dissent. And he essentially says, look, these words were chosen deliberately. Husband and wife were chosen by Parliament. That's what they meant. They didn't mean for it to cover other types of relationship at the time, same-sex. There was no provision for civil partnerships at the time. So for the court to come in and change that meaning is overstepping the mark and is essentially taking on the role of a legislature. And that's something with which, again, the Judicial Power Project agrees. And they say that it blurs the distinction between the judicial function and the legislative function. I haven't mentioned separation of powers yet, because I think the other principles are actually more helpful in terms of understanding the debate. But that's the key point that they've summarised there. But again, what do you think? What do you think if we were thinking of a response to the Judicial Power Project's point of view, what do you think others? How do you think you might defend the perspective of the majority in Guyton in terms of parliamentary intention?
Well, I suppose because Parliament has demonstrated its intention in legislating the Human Rights Act and particularly legislating through Section 3 of the Human Rights Act to sort of ensure that the Human Rights Act sort of infiltrates every other piece of legislation, because Parliament doesn't have the time to go through every act from Magna Carta right up to the present day and amend it to say and same-sex couples and people of any religion or ethnicity and disabled people and make all these other changes which will be necessary in the context of the updated legal framework.
Right. Yeah, that's a good point. So yeah, I think that's the key point is essentially the parliamentary sovereignty doesn't provide an answer in and of itself when you've got two provisions that are in conflict. As you say, you've got Section 3, and that's what they would say, that they did say, is that they were giving effect to Section 3, which is demanding that the courts take on this role. They're not giving it to themselves. They are actually giving effect to Parliament's intention, and they have to weigh up that the intention of the Parliament in 1977 with the Parliament's intention in 1998. And I think that's a very important point. When a statute seemingly conflicts with a constitutional principle, like parliamentary sovereignty or whatever, the courts are faced with very difficult, and this is what often gives rise to these hard cases with these divisions. The other point, of course, is that with this case, you've got a claimant, a real live human being, who has a problem in that he needs somewhere to live, and that courts are often, that often has an impact in terms of their decision. If they can see that there is a just result which can give a just outcome, then I think that increases. If we contrast that with Robinson, where the purpose of approach there again served to kind of solve a practical problem, but you get a sense of how the context might influence the approach. Okay, so we're doing, I think, vaguely okay for time. Move on to the last case study. So this is a bit more complicated. I chose this one. It's one of the main ones in the briefing paper because it combines both devolution and human rights. It's quite a recent case as well, and it's a lot more complicated. So I won't go into the sort of the details of the actual provisions themselves. But essentially, the main context was it was a private member's bill made by the National Assembly in Wales. And it was a bill which sought to transfer the costs from the NHS to private providers, not private, I think those who they thought were responsible for causing employers and insurers responsible for the industrial diseases, which these asbestos-related diseases. So they're essentially shifting, they're saying, no, you should pay for this treatment that the NHS has to deliver. And the questions raised by the case, essentially, because the senior legal officer of the Welsh National Assembly referred the case because they knew that it would be susceptible to challenge. So they wanted to get it through the courts before it was enacted so that it was sort of make sure that it was robust rather than enact it and then face the challenge, which would prove more complex. So it hadn't yet become law when it was referred to the Supreme Court under powers in the Government of Wales Government of Wales Act 2006. And the two main questions in terms of whether or not the bill was within competence, i.e. within the boundaries set by the 2006 Act, were whether or not it related to the organisation and funding of national health services, which I'm not going to discuss, and whether or not it conformed to the right to property as set out in Article 1 of Protocol Number 1 of the ECHR. So, as I'm sure many of you know, the 2006 Wales Act means that bills enacted by the National Assembly must comply with the European Convention of Human Rights. If they don't, then they're not law. So there's a kind of synthesis of it, and an additional layer of protection for convention rights in the Government of Wales Act. And so that's the question of on which I'm going to focus on. And it's interesting because, again, there was a majority and a dissent, and they divided on some of the issues that I've discussed so far. So to determine whether or not a bill violates one of the rights set out in the Convention essentially comes down to what's known as the proportionality test, set out here. Four limbs to the test. It's a bit legalistic, but essentially the most important for these purposes is the fourth limb, which is whether the benefits of the measure outweigh the disbenefits of infringing the rights. This is a kind of classic weighing exercise. So the way that the Act was infringing the rights was by retrospectively penalising insurers who, at the time they took out the contracts, couldn't have known that they would then have to be liable for something that they weren't liable at the time. The Act went back in time and made them liable. And so that's where the infringement came in. That's what the court established, that it did amount to an infringement of the right to property. So the question then was, right, it infringes the right to property, but is it disproportionate? Does it outweigh, do the benefits outweigh the disbenefits? So in evaluating whether or not the benefits of an act or of a bill outweigh the disbenefits, what are the courts going to turn to? And this is where it comes back to the issue of privilege and the boundary between the courts and the legislature. So they look to the reasoning given in debate. So the majority, Mance, who found that the bill was disproportionate interference with Article 1, the right to property, said we should pay attention to, we should have respect for the fact that the legislature is elected, that they've taken into account the policy, that they've looked into it and around. But the court, the bottom last sentence, may be especially well placed to evaluate private interests, which may not always have been fully or appropriately taken into account by the primary decision maker. So he's saying, look, the Welsh Assembly did a good job of looking at all the issues, but did they think about the right to property? And the way that he did that was looking at the reports, and he essentially found that they had not. And this is quite a significant piece of reasoning, where he said at the end here, my conclusion is merely reinforced by the consideration that this does not appear to have been the case. In other words, he looked at the Welsh Assembly debates and he said they hadn't considered sufficiently the right to property of those affected, and therefore that weighed in the balance in the sense that it was disproportionate. Lord Thomas was extremely critical in sort of polite judicial terms. This is I think, a very strong dissent, where he says, in every respect, a political judgment in relation to social and economic policy on which it is for the legislative branch of the state to reach a judgment. So essentially he's saying, this is not for us. Deciding how funds should be allocated, whether or not who should pay for NHS treatment, is not something that a court is well placed to do, no matter sort of the legal niceties. And the court should defer to the legislative judgments when these type of actions are raised. I've even got another reference. And then he goes on to the broader point, essentially a defence of parliamentary privilege. The principle, he says that we should be extremely cautious in letting the courts look at how parliamentary debate is conducted and interfere in any way with the way in which legislative assemblies go about their decision making. And that was sort of the note on which he ended. And again, the Judicial Power Project said, court seems to overlook almost entirely the deference to the legislature suggested by the court in AXA. So again, they just said that the majority didn't defer sufficiently to the fact that the Welsh Assembly is an elected body which has special expertise in deciding matters of policy. I think that's my last slide. So I thought the point I would end on is, how much deference should the courts show to elected politicians is the big question, I think, raised by the current dynamic of the courts, given rise by things like devolution, the Human Rights Act, and I think it's incumbent on all of us to have a view on that if you're going to be engaging with things like the changes to the Human Rights Act, the changes to the devolution statutes, and the like. And on that note, I'll end. Any questions? Shine.
So kind of, but on the last case, I think what I find interesting is the fact that if it was still a bill, so it hadn't been decided, so that issue of using the judges to kind of raise issues that you would think perhaps could have just been raised in normal parliamentary process, and you know that some of those points might have been raised by election members, so it's kind of that preemptive nature that seems very strange, because therefore it's not interpreting something that's actually been set.
Yeah, I think that's a really good point. Again, yeah, so if I had more time and this was a research paper rather than a library talk, you know, you could draw out the factors, you know, comparing the factors. But as you say, the fact that that case, I should have said, actually is landmark because they held that the bill was outside the competence of the National Assembly. That's the first time they'd ever done that. So, but that type of judicial first is not necessarily you can see that the fact that it hadn't come into law yet made it perhaps more likely to happen than if it had been enacted, where the stakes are higher, but the law's been enforced. So it gives you kind of a sense of sometimes how context can be relevant.
But so had it gone through kind of all the stages?
It had gone through, yeah, the procedure goes,
yeah,
exactly. It's just prior to royal assent, but it had been approved.
Wow, okay.
I understand that there was a case recently also about devolution and the competence of the Parliament at Westminster to legislate on a matter which did or did not involve Wales. And that it was the Speaker's certification of it as a matter which could be done through evil, which was challenged. And that seems to me to be, so I can't remember what the case is called, and I don't remember a huge amount about it, but that's not very helpful for you. But that seems to me to be squarely within parliamentary privilege.
Yeah, well, I think that's the issue, is that parliamentary privileges are long-standing, I think dates even prior to the Bill of Rights, and obviously these things like the Human Rights Act and devolution don't necessarily, they can be intentional, can't they? And I think one of the reasons I started working on this issue was because of evil, because what the Supreme Court says on the boundaries of devolution is relevant now to how things are certified in terms of being even known. Because if the Supreme Court says that something's not within devolved competence, or it is within devolved competence, that will affect how matters are decided in terms of evil, even if it's indirect.
I may not have followed Lord Mance's reading properly, in which case you can just, I suppose, correct me, but is it not open to the Welsh Assembly, this having been said to be outside the competence on the grounds that they're not given proper consideration, etc., in proportionality sort of business, to just go back and give proper consideration and put together some nice graphs and pie charts and then go back and say, well, we've done a good job now?
Yeah, well, another point which I didn't cover in the detail was that they also found, the majority also found that on the first point that the provisions didn't relate to the organisation of National Health Service. So it was an academic point, second one. So yeah, the case for the majority didn't turn on the human rights point. It just so happened that he thought he would deal with it as well. But he found that it didn't relate to National Health Service. He thought it was, I can't remember what they decided it was, but it didn't have there's a specific wording that the court uses in terms of understanding what relates to means. Relates to means something like more than a substantial connection to a subject. And they found that this wasn't really about the health service, but was about funding. All right. We're done for time. I think on that note, if there's no more questions, then
one more. It's quite controversial. So
okay.
To ask. So there's a judicial review action that's been brought by I think UK citizens who have been living overseas for 15 years to challenge the franchise for the referendum.
Yeah, it shouldn't have.
Yeah. How do you think that's going to go?
That's already happened.
Oh, it's already been decided?
Yeah.
What was the outcome?
That was before, yeah, the Supreme Court heard it, and it wasn't even arguable.
Was it admissible?
No, they said it wasn't even arguable, and the Court of Appeal gave the fine. But yeah, but these issues were going to come up again and again. I think that's for sure. Right, again, well, thanks for coming. And